All right. So what you guys just looked at again was the idea of again we've got parallel court systems, three tiers. Within those three tiers, two types of cases are working their way um, up through there, and our focus typically is at the top of the pyramid. We look at the Supreme Court. Um, they're the court of last resort. They make a kind of final decisions. They've got to be the most important court. So we zoomed in on all the factors that surround appointment. But as I was trying to point out yesterday, um, on average, how often does a president get to make these appointments, right? And it's not as often as you might think. Um, I had mentioned with, Eisenhower had quite a few, but I had mentioned with FDR. Obviously FDR had a whole bunch. And if you go back far enough, there's presidents that had quite a few. Um, Washington, I believe, made, I want to say it's like 10 different appointments. 2 terms, the court was new, so of course he gets to seat everybody. But looks like there was some turnover in that particular court. So at any rate, what jumps out at you maybe is, you're going to see these kind of twos more often than not. Ford gets, one. Carter doesn't get any. So Nixon jumps out with 4 confirmed. Reagan will jump out at you, with 4 confirmed. The others get, 2 if they're lucky. Some get 0. So, we focus a lot on the appointment process of Supreme Court justices, but it doesn't happen that frequently. And to contrast, when we look at Nixon and Reagan, they had a lot of appointments, but, you're going to see in the video, the conservative appointments they made didn't swing the court as far to the right as they would have liked.
Why don't they try to put younger people on the court?
To kind of, and that is often a strategy. This idea of I'm going to retire these justices into the judiciary. I'm going to, they're going to be 20 years old, and I'm going to, have them there for 60 years. That might be a consideration, but I think when you look at appointments, you obviously want a reliable legal body of work so that you can kind of predict where they're going to go over time. But we'll look in a second at some of those other external factors. The other thing I want to kind of point out is not only did the court not swing in their direction, when you look at Kennedy, I forget how many appointments he had, but his most critical appointment was this a liberal, Arthur Goldberg, because he tipped the balance. So one appointment might outweigh a person who gets 4 appointments because you have to look at the balance of the court. At this point, it was kind of evenly split between conservatives and liberals, and this swung the balance. So Kennedy, in many ways, had a more impactful appointment with one than these others did. Now, the other thing that, the reason why I think our focus on the Supreme Court is kind of skewed is, the number of cases that we're going to look at. So let's open to the right page. Look at the chart that's right here on your left on page 258. Jen at home here in a second. She's going to get to see my audio-visual department. All right. Here you go, Jen. Can't get it lined up. There it is. Let her study it. All right, so what's the trend that you notice there? Look at, you have to decode this. This will be kind of a theme within the multiple choice section. You might get thrown a chart and asked to kind of identify trends or answer which of the following is true. And what I'm really interested in is that kind of bottom half of the chart. What happens is I'm walking from the left-hand side to the right-hand side. What's happening to the numbers? They're going up. So the first chart kind of shows you how many justices they appoint to the Supreme Court. And as I walk to the right, I'm seeing how many justices they appoint to the appellate courts and the lower court systems. So the conclusion that you draw from there is that the president will have far more impact in terms of appointments where? Where are they having the most impact in terms of the power of appointment? On the lower courts, right? And we miss that. We don't kind of pay attention to that as much. What is the red and the green showing you? What's that showing you, Alex?
It's the percentage of accepted judges that are appointed.
Good. So, when I'm looking at it, I'm seeing, the number of, in red, the number of justices appointed by a president by the end of their term. So I'm getting to see what percentage of the judiciary is made up by that president's appointees. Therefore, the green is what? The one, well, not necessarily denied. Read it again.
Oh, some judges that weren't appointed.
Yeah, so you're getting to see kind of the breakdown as to like how much impact does each president have on the court. And you're going to see, is it 50-50 or, if you look over at Bush, the majority of the court was, not appointed by him. All right? So this gives you a sense, again, as to how impactful the president is. So obviously our focus should be more on the lower courts, and it's not necessarily. We kind of miss that. And there are a couple of nuances that you want to think about. We looked at all the factors that, you look at when you're appointing a Supreme Court justice: merit, ideology, their demographics, on and on it goes. And those considerations factor in here as well. Same thing with lower courts. But there's a couple of other nuances. One, just because terminology is important, is something called senatorial courtesy. If, you are appointing a trial judge on the federal level within the state of Massachusetts, the person that you're selecting or nominating, you run past the Massachusetts Senate delegation first, out of kind of courtesy. Hey, we're picking somebody to be a justice in your state, from your state. You are the kind of the expert on your state. You're the authority within your state. It is proper that I run them past you. It's also going to increase my chances of support for that individual when they come up for nomination in confirmation. Okay, so that's one nuance. Carter and Reagan had different tools to kind of try to handle the volume of cases that they had, or not the volume of appointees they had, and take ideology, as a factor. What Carter did is he did merit selection panels. What he wanted people to do when they brought him, the people under him, when they brought him a list of potential nominees, was to have considered the demographic background. You're going to see this in the chart on page 259. This is common. I've seen this in a lot of the multiple choice, having kind of looked at and comparing who appointed more minorities, who appointed more Hispanics. And so, just a simple decoding of that chart. What you see Carter did with his merit panels was he tried to really proactively look for underrepresented groups. And consequently, if you add, yes, there's an awful lot of white males, but, a third of his appointees were made up of Hispanics and African Americans and other females who would be considered kind of a minority group, at least in terms of representation within government, okay? What Reagan did was he did kind of background surveys. He had a kind of a panel put people through an ideological test to try to figure out where they were ideologically. So different presidents might emphasize different things when they're looking at the hundreds of appointments they need to do, and they might have a system for it. I've got a kind of a diversity panel, or I've got an ideology kind of screening test, right? And again, I'm going to run it past the senators who are, directly affected using senatorial curiosity, all right? So again, the focus, I think, is off because, one, the number of appointments to the Supreme Court is not tremendous. Two, the majority of the appointments they do get to make are on the lower courts. And then three, flip to page 263 and look at that chart. Figure 9.3. Here you go, Jen. What do you see there? Page 263, chart 9.3. you see? What's the trend? What makes, again, our focus on the Supreme Court a little off? Good. What do you think, Alex?
A tiny fraction of cases filed are actually decided.
Yeah, so we're looking at the number of cases kind of filed in and versus the kind of cases decided, right? And what's the contrast, Nick, between those numbers?
There's like thousands that have been filed, but only like hundreds.
Yeah. I mean, they take on, when we look at the kind of percentage, 99% of federal cases don't reach the Supreme Court. They take about a 1% of cases from the entire, judicial process. And, when I compare 9,000 in 2005 and 6 to the 88 that they took, that tells you something, right? So again, our focus may be kind of off, but let's keep it there anyways, right? One of the things that you would look at is, the trends in terms of selecting a case and how that might affect the judicial process. So this is actually kind of spelled out for you guys on page 263, not 263, 264. So if you want to see it in a kind of a graphic as we go along, since I'm torturing Jen at home. That chart. It's kind of fun for me. All right, so again, one of the things that you would be looking at is, factors that lead cases to be selected, factors that lead cases to be turned down, and then maybe an analysis of, kind of the pros and cons of some of the things that, how does it affect the legal kind of process, because they have these mechanisms. Is it good or bad in terms of what they take and what they don't, right? So most of the cases come from the federal side. About 10% of the cases come from the state side. Very rarely does a case go right to the Supreme Court. Those cases of original jurisdiction, as we looked at the language, are really rare. And the way the process is going to start is with something called this, I got to pull this up on dictionary.com, a writ of certiorari. I think I said it right. I'll find it and we'll play it for you in an audio and see if I really butchered it. Well, what you see in there is writ means right, certiorari, if I said it right, means certain. Fortunately, you're taking a paper and pen test. No one will know if you mispronounce it when you write it. It means to make certain. What it is, the way the process starts, is lower courts request to the Supreme Court, or request the Supreme Court to take their case. They want the Supreme Court to make certain that they got it right. So requests kind of come from the bottom up. We did see in the video, occasionally the Supreme Court is dying for a case. They will advertise for a case. Remember that flag salute case they didn't like. But you would ask the question, can they go get it? And no, they can let all parties kind of know, hey, we want this case. They can signal it in a number of ways, but it has to start with this writ of certiorari, or whatever that says, right? Again, that's a request to the Supreme Court to order, come look at our records, look at our proceedings. We're asking you to ask us to send you everything that we looked at during this case because there's some special or extraordinary reasons. Now, those writs don't go immediately to the Supreme Court justices because, again, what was the high number of cases that were coming to the Supreme Court on appeal? How many writs of certiorari did they receive in a kind of a given docket year? Yeah, thousands. Do you think the 9 justices who are elderly and, want nap time built in, do you think they're sitting down combing through those 9,000 kind of requests on any given day? So what's an efficient way? What do we use in Congress that we're going to kind of use a version of here? There's all those bills, and we don't sit and have members discuss them on the floor. We break them up and send them where? Who looks at them first? Committees. I need a kind of a committee system here, and that comes with the law clerks. A lot of those people talking in the videos were former law clerks. And my gosh, if you're a clerk for a Supreme Court justice, can you write your legal ticket that way? You've just kind of clerked and done major legal work for some of the greatest legal minds out there. Your professional career is set. So these are clerks, but they are very prestigious. They are kind of top in their law class, have done all kinds of impressive kind of work in terms of their career, and they do the initial screening. So when I said you're not just looking at the process, you're looking at the pros and cons. Well, here's a filter, and the pro is it's efficient. The con is there's kind of people deciding what gets put in front of the chief and associate justices and what isn't seen. So they're kind of informal justices that skew the legal process. They're kind of like this intermediate court of review. Each justice has a pool of clerks, and the clerks will bring cases that strike them to their justices, and the justices in turn will submit the cases they want under consideration to the Chief Justice. It's known as a discuss list. So basically, as the clerks kind of do their filtering work, there becomes, with each kind of associate justice and the Chief Justice, awareness of certain cases that they want to discuss, and it gets put together in a list. And then they sit down for a conference and they discuss, okay, out of this list, hey, you wanted to talk about this one. Tell me about this case. Why do you want to consider it? They'll workshop the kind of the cases that they have on their discuss list, and then they'll vote. And the rule is called the rule of four. If four justices, after kind of talking about the cases, think that it's a worthwhile case to take, they will put it on their docket. They need at least four in this conference to consider taking a case. Okay? If they don't get four to say, yeah, it's worthwhile looking at, it goes on the dead list. Now, why is that still significant? Right? Cases they take and the cases they don't take are almost equally as important. What happens when they don't take a case? What's the legal impact, Nick?
The court decision already made is
Yeah.
final.
It lets the earlier decision stand. So either way, they're making kind of a ruling. Now, out of the 9,000 that they considered, why did they take the 88 that they did? Nick, you had asked this question yesterday about how we have these different circuit courts and they have, rulings that apply to this particular geographic area, but what happens if they're inconsistent? Well, that's a number one factor as to why they take a case, right? When they see this kind of lack of consensus. One of the major functions of the courts is to make sure that we have kind of legal consistency. So if they see a disconnect, they'll wade in. If they see, hey, we made a ruling earlier with regards to privacy, or we made a ruling earlier with regards to due process, and it's being misapplied, they will want that kind of case. Again, sometimes there's a constitutional issue that they're just itching to take on. The flag salute case was, the example from the video. What I think they've been waiting for in some levels is a consensus with regards to same-sex marriage, and as they see that develop, they're more willing to take on those kind of cases. So typically what they look for is, an issue, where they do a lot of their rulings is with civil liberties and civil rights, obviously. They're constantly trying to define where liberties kind of end and pick up. California just had a really interesting ballot initiative, I think it was a ballot initiative, about whether or not you can mandate inoculations. You following this argument at all? There are people who believe that inoculations lead to an increased risk of putting someone within the autism spectrum. I'll be frank with you, there is pretty much no scientific evidence to indicate that. There is some people who have gone on the web and seen studies that indicate perhaps, there's some kind of correlation, but there's no scientific evidence that there's a direct relationship between inoculations and putting someone on the autism spectrum or putting them at an increased risk. However, if you get sick, do not go on the web. You do not want to read what's out there. It puts people in a state of panic, and they're not inoculating their kids, and consequently diseases that we had eradicated in the Middle Ages are coming back. Does a person have a right, based on a fear of, whether it's founded or not, of refusing inoculation for the kid? You would say, and it was, I should play this, this clip that I had heard, because there are people screaming, literally, we want our freedom. We want our freedom, right? But what do we know about freedoms? Freedoms overlap, and your freedom is not an absolute. So if you don't inoculate your child and then you send him to a public school, what right is all of a sudden being overlapped? got a child that's uninoculated carrying around what?
Well, I was gonna say, the first question that
Go ahead.
triggers something like the other kids because they can get sick.
They can get sick. That's exactly it. They're carrying around some sort of, disease that had gone dormant, and they're carrying around a strain of it that could potentially infect other kids. So that's the kind of case at some point the court may weigh in on. This idea of, okay, I've got freedoms overlapping. Someone feels it's their freedom not to inoculate, but we're endangering other kids by exposing them to illnesses, all right? So at any rate, those are kind of the trends with the types of cases. What they also might look for is cues from other groups. Is the NAAC behind this? Is the ACLU behind this? Are there certain civil liberties, civil rights groups that are knocking at our door saying, filing briefs, asking us to take this case? Is the Solicitor General knocking at our door saying we should take this case? Remember, we talked about the Solicitor General. What's the job of the Solicitor General? I've got an Attorney General, they're the top law enforcement official. They're the ones that essentially are in charge of any kind of legal decisions within an administration. What's the Solicitor General do?
They present the government's case.
Yeah. So this person is the best kind of trial lawyer you can imagine. They are constantly presenting the government side to the Supreme Court. They do the filings of the briefs with the Supreme Court. They do the oral arguments. If the Solicitor General files an amicus curiae brief, meaning what? Amicus curiae. Kelly's close. What do you think it is?
It's from a third party that has their interests.
Yeah, third party kind of brief. I'm not a direct party, I'm filing it. What's in amicus? Amicable. Friend, right? Amicable. Friend of the court brief. So if the Solicitor General files an amicus curiae brief, you can bet the Supreme Court will perk up. They consider the Solicitor General the 10th justice. That's how they define them. I got it underlined there. Okay? So here are some factors in terms of why they would select it. We looked at the type of case, we looked at the type of interested party. The trend, though, is court is taking less cases. So again, you can picture this question about compare and contrast. Why would they take a case? Why wouldn't they? And what parts of the process increase the chances of taking a case or don't. There's lots of ways to kind of consider a question here. The fact of the matter is that there is a rise in appeals. We're an incredibly litigious society, and yet the Supreme Court number of cases they're taking is going down. The question is to why? Well, one of the answers might be we've worked a lot of the constitutional issues out. We've had kind of 200 plus years of the courts reviewing of law and the Constitution, and we're starting to figure out what we mean by speech. We know that speech can be restricted if it's presents a clear and present danger that leads to imminent lawless action. We got that kind of worked out. We know that we have privacy, and we've extended it to medical decisions. So maybe we're kind of we know about due process and what we believe about warrantless searches. We've worked out a lot of the issues, and therefore maybe don't have a lot to consider. But an underlying factor might go back to like Reagan and his ideological panels that he put, or surveys that he put together. You might go back to the idea that appointment has become polarized around the abortion issue, and therefore we're looking for just appeal court judges that are like Souter, those stealth candidates that haven't ruffled anybody. The appointment process may have led to an ideological consistency, and consequently, the Supreme Court and its structure looks similar to the lower courts, and they see things the same way because they're kind of similar. There's also this idea of risk aversion. The court is 9 individuals. They rely on the implementing population. That's both, President, Congress, but the public as well. If they put themselves too far out on a limb, like Cherokee versus Georgia, it becomes very quickly apparent that the emperor has no clothes. You get the reference? Right? You pull the curtain. How many of you have seen Wizard of Oz? I don't want to spoil anything. Spoiler alert. They pull the curtain back. You're looking for the wizard. Who's there? Come on, it can't be that long. Is it the wizard? The little guy pulling levers, right? Little guy that's not quite a wizard. He's pulling levers to make the big booming voice and things like that. So, hope I didn't ruin that for you. at any rate, the Supreme Court is just 9 guys in robes. They're not going to come riding down to your house and make you kind of, follow their decisions. So there is some risk aversion. It's the same thing for the clerks, too. They don't want to stick their necks out too far and ruin their legal career by suggesting something absurd that, the court isn't ready to rule on. All right? Having looked at the first step, the process of taking cases, let's look kind of quickly at the process of deciding cases. And this comes back to that chart that you've got in front of you if you want to follow that way. Step 1 is, the submission of briefs. Okay, we've had the writ of certiorari, we did the rule of 4, it got, it got on the discuss list, we then used the rule of 4, we decided to take it, now I want your formal written arguments. And the irony is they're called briefs, and briefs are anything but. They're thousands of pages long. And when I first came out of college, I worked as a paralegal for a law firm that specialized in international trade. And they were just mind-numbing cases about whether or not these sweaters imported for Taiwan violated a trade agreement. And the lawyers that I worked for would put together briefs, and they were thousands of pages long. And I used copiers from the 1990s that don't look like these, super machines. And my job was to print up like 400, 500-page documents and make sure that they all were in the right sequence and nothing got folded, spindled, mutilated. I did not do that job very well. I got bored after a while, looking to see if it had pages 1 through 500. That's why I lasted a year there. It's tedious kind of work. And then what they mostly look for is something called scope, right? Cases have been tried before. And what a big legal strategy is to say, hey, there was a case that was decided a while ago in our favor. What I have to argue is that my case is just like that case. They look for scope, okay? But that happens within the briefs. Then there are these oral arguments. And I got to imagine this is intense. Because parties from both sides, and if the Supreme Court decides to allow the third parties, the ones that file the amicus curiae briefs, they get to as well. But the court has limited time and, has a lot to kind of consider, so you have limited time. They give you 30 minutes to speak. So you have to go up in front of the bench, the 9 justices, and you're going to give your 30-minute oral argument. And in the meantime, they pepper you with questions occasionally. They'll just fire a broadside out of nowhere, and you've got to kind of, respond to that, and still your clock is running. Nick, you had asked about, why does it seem like the court is secret? Can't you kind of go see their proceedings? Well, you can, but there's limited seats. So you could line up early in the morning and, provided you were in D.C. when they actually are in session, and they're not in session year-round, and you could try to, watch the Supreme Court. But it's not televised. For whatever reason, since like 1955, I think it is, they have been just doing audio recordings. Now, you got to be a major, major kind of political science geek to go home and listen to this. Anybody want me to shoot you the website so you can go home and listen?
We'll get argument first this morning in case 14-144, John Walker versus the Texas Division of the Sons of Confederate Veterans. Mr. Keller?
Thank you, Mr. Chief Justice, and may it please the Court. Messages on Texas license plates are government speech. The state of Texas etches its name onto each license plate, and Texas law gives the state sole control and final approval authority over everything that appears on a license plate. As in summa, Texas is not abridging any traditional free speech rights. Motorists remain free to speak in all sorts of ways, including on their cars through a bumper sticker right next to a license plate, or a car-sized paint job or a window decal. But the First Amendment does not mean that a motorist can compel any government to place its imprimatur on the Confederate battle flag on its license plate.
Well, one of the problems with the scheme is its nebulous standing
That's Ginsburg.
would be
Ruth Bader.
regarded as offensive to many people. Is it government speech to say mighty fine burgers to advertise a product?
The government,
So what I love, I didn't even know that was coming. There's Ruth Bader Ginsburg, just kind of, in her halting voice, firing in he has a whole prepared kind of, thing that he's going to say, but he also has to be prepared for what kind of questions are they going to ask, and they'll come in at any moment. That was actually more engaging than I thought. You guys want me to keep playing that? The whole idea about can you put the Confederate flag on the Texas license plate? Or is that, is that free speech, or is that the government sanctioning, what many consider to be a pretty reprehensible icon? Some Southerners would argue that it's part of Southern history and Southern pride, and it stands for something larger than slavery. Others would see it as, like I said, an iconic image of the South and its support of slavery. At any rate, you have those oral arguments. And then they're going to go into a judicial conference after they've heard the arguments, and they'll discuss. And they'll tentatively vote. Based on that tentative vote, what I want you to see is it's a tentative vote. They will then assign the writing of an opinion. Now, we're not final yet, because the writing of the opinion is critical. You're not going to sign your name away until you see all the terms of a contract, right? I want to see it in writing. So yes, we've agreed tentatively that these license plates are, voters can't compel the state of Texas to, issue these license plates. It's not a violation of speech, but I want to see how you write it, and I want to see how you talk about speech. And once I see it in written form, I'll decide whether to sign on to it or not. Now, based on how they sign on to it, you've got different kinds of opinions. Majority opinion is, obvious, right? If I didn't teach you the course, you'd still have a fighting chance of getting that one right. That's where a majority of the justices agree on the verdict and the legal rationale. A concurring opinion is where I agree on the verdict, but I might dissent a little bit as to how the legal kind of steps we took to get there. So I might have a different idea as to why this is constitutional or unconstitutional. Plurality opinion, right? I don't have necessarily a majority, but I have a consensus. And, there's a consensus, but it comes for a variety of different legal reasons. So this is a single justice kind of having different legal reasons. This is where I have a consensus, but they're all coming at it maybe from a different direction. Obviously, a stronger ruling is where you have a stronger consensus. Why the pure curiam opinion is perhaps the most powerful, because this is a decision by the court, unsigned. Do you get the impact of that? If I have Roe v. Wade and I know black men wrote it, I kind of hang that, decision around him. And I can kind of say, well, that was his decision. Or he's the one who kind of wrote the opinion. And these are the justices that supported it. They're not representative of the whole body. This is a unanimous kind of signature and an anonymous one. It has a little more impact. Not to be ignored is the dissenting opinion, which is where they talked about Black in the video, getting to write freely in terms of his dissent. It was liberating. He didn't have to worry about ticking people off and losing people from his side. And what's the significance about one day's dissenting opinion? We're a couple appointments away from it becoming what? Yeah, the majority opinion. So these are important in terms of how you write them, because it becomes the legal groundwork for a future majority opinion. All right? Again, it's tentative, because what you have to do is you have to float it past the other justices to see if they like the language. Hey, you put in the word "with all deliberate speed." That kills it. I don't want to sign it anymore. Right? So once it's written, the written form is circulated. There's lobbying going around. Remember they talked about Warren, who was a former governor, walking the halls and actually kind of working like a politician to get people to sign on. Once you get them all to agree to sign on, then it becomes final and they announce. All right? So again, I've got, I don't know, maybe 20 more minutes. And I don't know where I'm going to find it in the schedule, but we'll try to find it. And you guys know the drill tomorrow, right? You can work, it's a working period for study guides and for those essay outlines. When do those due? Tuesday, or if you're, again, upon your departure, before you leave. Unless you want to somehow electronically send it to me from Disneyland.